One of you, please give Mr. Kiprop space at the front.
Your Honor, what is not disclosing, later can confirm this.
Yeah.
When I saw he was likely going to miss seat, I confirmed with Linda. I even requested Linda. They were brought 3 seats, which they did not think were comfortable. They took here. Then those
because give him a seat at the front because the state is the state.
Yes, that's what I was pleading with you. Ask even Mr. Mari, maybe ask him if I could please sit here, and he has refused.
Mr. Magolo,
Yes.
Do not offer Mr. Kiprop a seat that doesn't look very comfortable.
I didn't realize that. I just saw seats were seats. But particularly wanted this one occupied by Mr. Mboya because it's sweet.
We have been having a debate.
Yeah.
Is it them who are senior or is it the attorney general? It's a serious issue. But that is off the cuff.
Mr. Kiprop?
Thank you. Yeah.
We are here because
Oh, you wanted to be under the fire? Yes.
Yes, Your Honor, I appear on behalf of the state.
Yes.
Together with Mr. Susioka
Yes.
and Mr. Singh.
Present.
Mr. Kiprop, Mr. Musioka, Mr. Singh.
Mr. Singh.
and for the defense.
Yes.
We have Mr. Mboya,
Yeah.
Mr. Mboya, Mr. Wamboi Shaka.
Good morning. I am Mr.
Mr. Osoro, I'm President. Mr. Ediesa,
Present.
Mr. Koko,
Present.
and Mr. Kai, together with Mr. Omari from the defense.
Anyone who has been left out? No, that is what we refer to as a battery of lawyers, or an argument of lawyers. Any other appearance? The LSK? Not here today. Mr. Kiprop.
Your Honor, pursuant to your ruling delivered on 2nd of May 2023, we appear before you for the state to give the status report on the ongoing investigations. Your Honor, this morning we filed a further affidavit.
I haven't seen an affidavit in this file.
The affidavit is dated 4th of May 2023 and sworn by Mr. Joyce Oyuki, one of the lead investigators in this matter. Your Honor, the investigations are still ongoing.
Give me a minute.
Sorry?
Your Honor. fact, I wanted you not to even read it.
It's part of the record, Mr. Wambeta. Is the affidavit served upon the respondents?
Yes, yes, I have the affidavit.
Are you standing on the preliminary points?
Yes, yes, yes.
Yes. Yes.
You know, this is a matter that you had already made a decision on the last annual court. I believe that if the state wants to reopen up this matter, and they are coming by way of an affidavit, they should seek leave of this court, first of all, to file in a further affidavit.
Mr. Wambeta,
Yes.
my view then is that
Yes.
you respond after he has made his submissions.
Yes.
Then you can state all that you're stating. Yeah.
What Mr. Cliff is trying to say
Yes.
that if they are allowed to argue the application, there's no application before. The question we are raising is just like appeal. Is there anything before you? So that once the court pronounces itself that there is a document before you competent to be submitted on, then they can submit.
But that can very well be part of the response. And the court will make a decision.
We are avoiding the question of content being submitted on, then we respond. We are simply seeking a procedural question. Once that procedural question is dealt with, then
Okay.
substance that
All right. Then raise your point, Mr. Wambeta.
yeah, Mr. Cliff, then join.
You know, we were saying that a further affidavit in a matter that has already been determined by the court cannot be extended by a further affidavit. It does not have a life of its own. So the first thing they needed to do was to seek leave of this court, which they have not done. So from the word go, you need to stop them at this particular moment. You understand the application that the affidavit that is in court right now seeks to ask that the respondent here be held for a further 30 days.
And that is the problem.
Yes.
You want me to disregard that affidavit,
Yes.
yet you are referring to it. How do I do that without going into it?
Well, let us start by the issue that they do not have audience before you without seeking leave to file that.
You have to confess our submission.
Mr. Mboya?
Your Honor, to buttress that position of my learned senior Mr. Cliff
Mr. Ondeta?
or Mr. Obeta, courts will only issue orders specifically prayed for the law of such orders is not an affidavit. An affidavit is evidence. A notice of motion needs to be in place. Supported with the grounds and a supporting affidavit. The law on miscellaneous applications is anchored on the civil procedures. It's nowhere in the criminal procedure code. Therefore, this document is incompetent for this purpose as a document to be presented before the court for the purpose of seeking orders. Now, secondly, the matter before you is 075 is already determined. It can only be appealed against it cannot be made a subject of review now. When the timeline set by this court has elapsed. One will review sentence.
In 1 more minute, Mr. Omari, 1 more minute. Yes. One more minute. Yes.
Your Honor, one will only be allowed to review a sentence when it is running on, not when it is complete. The respondent was sentenced, if that is the right term, for 2 days. For 7 days, he has served. If they wanted to review that decision, it could be before the expiry of that time. Lastly, Your Honor, is that we completely object to such tactics by the state to these tactics. I wouldn't want to talk about the content of it, but we vehemently reject, let the respondent go home or a charge sheet will be produced before it. Mr. Soro has only one word.
Your name, if I may.
Hold on. Yes.
Yes, the state has run out of ideas on how to punish the respondent. We came here.
Your Honor, we will object to that kind of language.
I am already
I'm not letting that go, Your Honor. The state,
We can fight about this for hours.
We will fight.
And let me finish.
Your Honor, don't allow that kind of language to be used in our court.
Mr. Osoro,
Let us be polite one another.
it is okay. That is noted, Mr. Osoro. Proceed.
Maybe you honor, then maybe we paraphrase. The state has decided to shifting goalposts. Your Honor, the ruling that was delayed by the Supreme Court on the 2nd of May, specifically order number 2, that this matter shall be mentioned on the 4th of May 2023 at 09:00 hours for the state to appraise the court on the status of the investigations and for further orders. The court never asked for further affidavits. The status report on the investigations. You expected to come with the attaching or tell us that this is what we've done or give us some evidence. It will even support their malicious application to keep holding on the respondent. Such kind of documents are what the Supreme Court called hot air. It's full of sound and fury signifying nothing. And this court has the powers to arrest such an injustice being perpetrated by the state. Your Honor.
Can I say just one?
Hold on, please. Mr. Mboya.
Your Honor, you have heard the objections and in my view they all have merit. Your Honor, considering the time and the schedules and the need to move, I wanted to say to request and suggest, Your Honor, that you give us direction so that we proceed, so that Mr. Kiprop, though he really has nothing to say, but can say all of it, so that we don't make application, ask you to make a ruling, we come back again, because our interest now is that Ezekiel should not be in custody any longer. The more we take you around, we may end up keeping it long. I suggest that you direct in a manner that we proceed and finish up, and whatever, and you can even order the striking out of the affidavit, and Mr. Kipro to say what you want to say, we reply, and we finish it.
Your Honor, with all due respect, we appreciate what the defense is saying, and we hear their various arguments. You have been invited to look at your ruling, which was delivered on 2nd of May, 2023. And particularly, you have been referred to the last paragraph of your ruling, which says that this matter shall be mentioned on 4th of May 2023 at 0900 hours for the state to appraise the court on the status of the investigations and further orders. Your Honor, it is upon this subsection B of your ruling that we are before this court to appraise the court on the status of these investigations, and if there are any further orders that the court will grant, then we will make that application. I'm afraid that is what the learned senior Mr. Pro had started with. That is the first thing that in his submission he stated that the court had directed that we appraise it of the status of the investigations. That is when Your Honor invited the state and asked whether the application had been served.
Okay.
So I would agree that we can take directions based on Mr. Magolo's submissions. However, before the court does that, I will invite the court to consider two issues. Mr. Kumari raised the question on the matters of civil procedure. This court is guided by the Criminal Procedure Code. And in any event, if the Criminal Procedure Code has not given express provisions on how this court is to be moved, which we are going to rely on, see where we were, one of the orders was, will be at liberty to apply for any appropriate orders, which we are currently doing. Then the court is also invited to look at the Constitution, where the Criminal Procedure Code is silent on the way we are to move court. Under Article 159, Your Honor, if I may read Article 159, which I'm sure the defense counsels are well aware of.
Sub-article?
159, sub-article 2D. That justice, judicial authority is derived from the people and vests of the people by the courts and tribunals established under this Constitution. In exercising this authority, the courts and the tribunals shall be guided by the following principles. Now that moves me to sub-article D, that justice shall be administered without undue regard to procedural technicalities. Now, if the Criminal Procedure Code, which is the basis upon which we come to this court and has the procedures by which we are supposed to move this court, is silent on how we are to move this court, then I invite the court to refer to Article 159, which is the supreme law of the land. And basic law tells us that any other law which is inconsistent with it is repugnant to that extent of inconsistency. So, even as I rest,
1 more minute.
even as I sit down, Your Honor, I invite the court to look at that provision in light of the submissions by the defense counsel.
that the final orders in the ruling that I rendered on the 2nd of May were clear that the purpose of today's mention was for the state to appraise the court on the status of the investigations and for parties to apply for any other further relevant, desired or appropriate orders. An objection has now been raised targeted at the further affidavit filed today, and the respondents' counsel seek that the same be expunged from the record. By practice, applications made to a court handling criminal cases are either orally preferred or by way of notice of motion. This is a practice that has been adopted in our jurisdiction over a substantive period of time. And that being so, and following the orders on the 2nd of May this year, giving leeway to the parties to apply, it is within the rights of the state to prefer the application orally and base the same on affidavit evidence. There are hordes of decisions from superior courts. I have one in mind, Kisia Investments. I don't remember the other parties. There are hordes of decisions from superior courts that the title of an affidavit, in this case, further affidavit, is a matter of form and not substance. The substance is to be found in the depositions made in the paragraphs where the deponent states his material on oath. It is therefore my persuasion that although the affidavit is titled as a further affidavit, the state can still rely on it to support an oral application. I, however, need to be clear that a decision on the application dated 28th of April 2023 was rendered on the 2nd of May, and I trust that parties will not revisit issues already determined therein, which would otherwise be rendered res judicata. The upshot then is that the objection by the respondent fails. Mr. Kiprop. Yes, Mr. Kiprop, you may proceed.
Thank you. As I was saying, the status reports that we are raising this court about is the new development that the investigators have come across, and I will rely entirely on the environment to this affidavit. Your Honor, the autopsy reports that have lately come out from that exercise.
I'm sorry?
The autopsy reports
Yes.
that have come out indicate that some deceased persons may have died from strangulation.
Mr. Kiprop, I've read the affidavit.
Yes.
I think you are repeating what's in the affidavit.
Yes, I just want
Unless there is something you really must highlight. I have read the affidavit. Yeah.
the important thing, Your Honor, here is that that information which is in the affidavit was information which was not before this court at the time we argued our application. Your Honor, that information has now altered We have been given by your ruling, and last one today. We are asking for 30 days, Your Honor.
Okay. How long has it been? It's been there for 7 days.
7 days.
So a total of 37 days.
Your Honor, the application, which I heard you say is just to the Kata, which is something which has been said. It's not actually just to the Kata. It was not under...
Not an application.
Yes.
I said, I did not say the application is the judicata.
Yes.
I said do not bring up any issues that would otherwise be rendered res judicata. That's what I said.
Now,
Yes.
that application, one of the statutes which was premised on that application is Prevention of Terrorism Act.
Yes.
Particularly Section 33. The state can request up to a maximum of 360 days. Your Honor, we are before you and asking for 30 days. I will leave my colleague, Mr. Simbi, to address you on the authorities that we are relying on to portray our reports and the changed circumstances that is now developing.
Before that, so now it is you're basically through what I'm saying here.
Yes.
You're now basically investigating the offense or offenses of murder.
Yes, based on what is coming out.
Yes.
And
But I'm wondering
yes.
whether murder then falls under quota, although you're presenting the application under quota.
Yes, but we are not limited to murder alone.
I'm looking at your affidavit.
Yes.
Because that is the status that I expected.
Yes.
Yes.
And in our application, which you captured in your ruling, we are also investigating other organized crime.
Okay.
Yes.
Mr. Simbi?
Yes, Your Honor. You know what the state is telling the court
Have you
is not...
have you shared those authorities
Yes, I have shared.
with the respondents? Or you're doing it now?
No, I have shared.
This is practice.
And I'm only going to refer to a few lines of those authorities. They can
It doesn't matter. As a matter of courtesy counsel,
Yes.
hata wewe ukipewa saa hizi, really, it is not fair. Yes. Yes. And even look at the same act you're looking at, Potter.
Yes.
It says, doesn't it say that the application, whatever application, and even whatever you're supporting it with, must be supplied to the other side? Yeah, the same act you're relying upon.
That's right.
Proceed.
Right. So, you know what we are telling the court?
The copies for the court, please. It's just one authority.
There are two authorities.
Let me have all the copies. I also don't want to be ambushed.
But the second authority largely backs up the provisions of the first authority. But basically, Your Honor, what we are asking the court is not something that is new. We are not asking the court to do something that is out of its purview. Your Honor, in miscellaneous criminal application number 162 of 2019, that is the trial Ibrahim Ali versus the Republic. At page 2 of the authority that I have just submitted, I will invite the court to look at paragraph 12, line 7, which I will
What page is that?
page 2 of 3 in Mukhtar Ibrahim Ali versus Republic.
Now, you asked me to look at
I invite the
Diana Suleiman,
Sorry?
They cited Diana Suleiman.
Yes.
Okay.
The one that cites Republic versus Diana Suleiman saying another.
Okay. A paragraph? Paragraph?
From paragraph 10 up there, and I will just quote briefly without going entirely through the entire authority. It says, with respect, I do not agree that a review of bail on the ground of changed circumstances or changes in the circumstances of the case, including circumstances of the accused, witnesses, victims, or the society affected by the alleged crime, is a strange phenomenon. I would say our courts do it every day when we seek to consider renewed applications for bail, such as when volatility on the ground is established to have ceased, or for the cancellation of bail on account of accused refusal to attend court on bail, when surety is withdrawn, or for other reasons. What my learned senior Mr. Kikop has submitted, he has invited the courts to look at the further affidavit that has been filed, and without going into what is contained in that affidavit, it is the state's position that since the last time we were before you in arguing the previous application, there are circumstances that have changed and that are put in this affidavit, that if the court looks through these circumstances, then it will warrant the court to grant the days that we are seeking to enable the state conclude its investigations. Paragraph 11 of that very authority says the change of circumstances test is one of common sense, that where the circumstances of the case are so altered that compelling reasons are disclosed for refusal of bail or review of terms thereof, the courts as a court of justice must reserve for itself a power to revisit the issue in the interest of justice. And this paragraph, if you read further, and I'm sure your Honor will retreat and read this paragraph, it opens this window to both this state prosecution hearing, and the window is also open to the respondent or the suspect. And we are telling the court that from the last time we were before you, there has been a change of circumstance that has occurred substantially that would warrant the court to go through and give a directive or give an order for extension of these custodial orders. So it is open to either side, but it so happens that in this case, it is the state that is moving the court for an extension of this.
The point is home.
Right. Without belaboring the point, as I finish, paragraph 12, Your Honor, on the first three lines only, the learned judge says, I find nothing in the provisions of Article 49H of the Constitution or Section 123 of the Criminal Procedure Code to suggest that once the court grants or refuses to grant bail, becomes fantas official. It is our submission, Your Honor, that based on the ruling that you delivered the last time we were before you, and in light of the provision of this authority, the court does not become factus official by virtue of the fact that it had pronounced itself to 7 days. This very court still has the powers, in light of the change of circumstances, to extend or give additional days based on aggravated circumstances or change of circumstances.
Okay. Change of circumstances.
Yes.
Can warrant review.
And
that is home.
That is it.
Yes.
So, Your Honor, we are relying on that authority and invite the Honorable Court to grant us the prayers of sort.
Okay.
Basically, Your Honor, without belaboring the point, I believe the other authority also speaks to the same authority. So, without wasting the court's time, I wish to pray that the state be allowed a further 30 days within which to obtain the corresponding to
Mr. Modelo?
Your Honor, the application today has reminded me of some things. Your Honor, when I was growing up in primary school and learning the English language, I used to believe that prosecution and persecution meant the same thing. Your Honor, today, in fact, it is confirmed that I was not wrong. Your Honor, we have before you a person who has been in custody for over 7 days. We have before you a person who, when required, over 2 weeks before his arrest, to go to the police station and make a statement, he duly complied. We have before you a person who, after an application had been made, and you looked at all the circumstances, a decision was made that 7 days was sufficient. We were therefore coming before you today to ask that you close this file and discharge Pastor Ezekiel. Your Honor, and it is my submission that despite everything that has been said, that would be the only logical decision we should make. It is now alleged that circumstances have changed. And a struggle has been made, even by way of affidavit and submissions to demonstrate those circumstances. They are not coming out. What has changed? From the application that you dealt with, they suggested that the investigation and the matters which the respondent was suspected of included murder, aiding suicide, abduction, genocide, crimes against humanity, child cruelty, fraud, money laundering. Now, when you look at the affidavit before you today, it seems that the investigations are zeroing on murder. Are zeroing on murder. To be subjected to autopsy, such that the results of that autopsy is not something new. It is not something unexpected. And it is not a change. It was clearly a procedure expected. And does those results affect Pastor Ezekiel? Ghana, your affidavit is short, and I submit that the answer is no. We are talking about the deaths which have all along been associated with another pastor called Mackenzie. From some farms which reports say belong to him, by members of a church which was said to be his flock, and Your Honor, now to drag this one here has another name. Its real name is witch hunting. Your Honor, it's my submission therefore that
2 more minutes, Mr. Magolo.
Sir, okay.
2 more minutes.
It's my submission therefore, Your Honor, that the result of autopsy is not a change. And it's not a change, particularly a change that they say should now amount to a compelling reason. Your Honor, the authorities that have been referred to you are anchored on Diana Salim, which, although properly well quoted and citation given, they opted not to agree. I happen to be conversant with Diana Salim. And Your Honor, the change in Diana Salim, which they are not disclosing to you here, is that Diana Salim had been charged with the offense of murder of one person. Remember the terrorist activities in Lamu. Then investigations revealed the death of other 60 people. Such that the change was from 1 count of murder to 61 counts of murder. That obviously was a change which can be described with its most compelling reasons. The change here is that all other offenses have been abandoned and they are coming to murder and they now have autopsy results. I urge that you don't at all give in to that suggestion. So what Your Honor is next? Your Honor, what is expected of you now is to direct that our client be at liberty, because he has not been charged and there seems to be, other than to persecute him, there seems to be no intention to charge him at all. Secondly, Your Honor, in the event that you feel that you want to give them some more time for whatever reason, though in my view they don't deserve at all, then Your Honor, we urge that you direct that the respondent be admitted to reasonable bail. Your Honor, it's a person you don't even need to ask to deposit cash bail or a surety. He's a non-evangelist. You can only ask him, Pastor Ezekiel, come back here on Monday, and he will come back. He just writes a note as you go.
So you're talking about a free bond?
Exactly, Your Honor.
Or a personal bond?
You're a personal bond. Even his word without committing it to anywhere, we will still come. That's all.
You know, the affidavit is very, very clear. It needs days for further investigation. 3 things. Post-mortem. He will not be required to be present when post-mortem will be done, so that you detain him because he will be required.
Postmortems or DNA?
For DNA.
DNA, not autopsy.
His
It says that the autopsies have been done.
His DNA sampling and analysis will be done in government premises to his exclusion. Number two, Your Honor, they are saying he is likely to be charged for murder. When they will decide to charge him, he will be available for that charge. He does not need to be in prison or in police custody for him to be charged. You know what? They are saying that he has a lot of influence. Even those who are dead will still have influence. The influence does not wane because he's in prison. It doesn't. He still remains the most prestigious televangelist in this country. So denying him that freedom does not curtail him. Now, let me buttress, so this affidavit does not provide new compelling reason to keep him. If this affidavit could have said he has contacted so and so and so who are witnesses, denied, that is not true. 2, he has been found escaping out of the country. That is not true. He has made a new passport to run out of this country. That is not true. There is no compelling reason to keep him. And Shadrach will deal with the question of the authority of Oscar Sudi on whether that is the only option to detain.
And I hope you have supplied it on the other side.
No, we have just been given this application now.
Okay.
And they are given the authorities now. Because their trick was, we asked for time to respond so that it continues being there. Now, let me lay the basis for the application for bail. Based on the circumstances that are there. We are urging this court to grant His Excellency Dr. William Ruto, who are released on board on bail. Their influence, first is a shadow, is an entity. They were released and they were doing their matters, and the offense they were likely to be charged is genocide. The offense now has become, I come back to this country. Governors, Obama, the case is there. Governor Governor Waititu, Governor Leporo.
I think as you submit,
I'm only giving.
No, as you submit, yeah.
Pastor Ezekiel ambaye sasa hivi anazungukwa na huu tata aliokokea kwa crusade yetu ya Tononoka mwaka wa 2000. Hapo ndio tumeanzana na yeye. Pastor Ezekiel amekuwa kwa kanisa la Maximum Miracle Center ambalo liko Spaki au lilikuwa Spaki miaka hiyo ya nyuma. Pastor Ezekiel akawa anacheza keyboard. Pastor Ezekiel baada ya yeye kutoka